This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
And contractual terms, again, like all of these things, they do come up in exams. Contractual terms, we need to split. Remember, a representation is not a contractual term. And I'm just looking now on page 9 of the BPP revision kit. Question 27, 28, 29. 27, in relation to the contents of a contract, explain the following: terms, conditions, warranties, and innominate terms. Question 28, in relation to the law of contract, distinguish between and explain the effect of a term and a mere representation. And then express and implied terms, paying particular regard to the circumstances under which terms may be implied into contracts. And then finally, question 29, explain the meaning of exclusion clauses, also known as exemption clauses. These are terms within a contract. These are a particular type of term within a contract. So these questions do come up, as do substantially all the topics that we've covered so far. So terms, split down into conditions and warranties. This is the meat of a contract. This is the detail of a contract. I can enter into a contract generally, for instance, to provide tuition services, but we need to know rates of pay, the dates, the notice period of cancellation. We possibly even anticipate the penalty payable in the event of breach of contract. We need to know the location and a number of matters clearly like that. So this would be the meat, this would be the terms within the contract. So this terms then subdivide into the two areas, conditions and warranties. And there is a major difference between the two, and the rights attached in the event of a breach of condition differ from the rights attached to a breach of warranty. A term which is a condition is fundamental to the contract. It goes to the root of the contract. It's the very basis of the contract. It really is fundamentally important. So a condition, a term which is a condition, if you breach it, then it's destroyed the whole effectiveness of the contract. There's a case, the third bullet point, breach of a term which is a condition allows the injured, innocent party to treat the entire contract as completely discharged and sue for damages. The question, or the case Poussard and Spears and Pond, was about a diva, a singer, an opera singer. And the opera singer was engaged to perform at 4 concerts and to attend a rehearsal period before the first of these concerts. We're going to want you to rehearse for a week, and then the concerts will start on consecutive Mondays. Before the rehearsal period was due to start, the opera singer contacted the promoter of the series of concerts, contacted the person who was organizing it and said, I'm very sorry, but I'm not going to be able to attend on the first concert evening. I can't make it. And nor can I attend for the second concert, but I will be there for the third and I will be there for the fourth. Well, the promoter's already sold a lot of tickets for these events, so he has to find an alternative. And instead of asking Bonita, who's given me this notice that she can't attend, the promoter turns to Sandra and says, can you do these first 2 concerts? Do you know the works? And Sandra says, well, yes, actually, I do know the works, but I'm not going to take a contract just for 2. If I do the job, I want all 4 concerts, not just 2. Well, in a state of panic or frustration or desperation, I say, yes, okay, I will give you, Sandra, I will give you the entire 4-performance contract. On the evening of the third contract, the evening of the third concert, Benita turns up and says to Sandra, "What are you doing in my dressing room?" And Sandra says, "It's my dressing room, it's my contract." Benita sues me. Does she win? No, she doesn't win. The contract is 4 concerts, and she's given notice that she's not going to attend those first 2. She's broken a condition. It's fundamental. What's the contract about? The fact that she turns up wearing an appropriate dress? Is it the fact that she attends for the rehearsal period? The contract is to sing at 4 concerts. And Benita has given indication that she's going to breach the contract. So me as the promoter, I can treat this contract with Benita as completely finished, and therefore I am able to engage the services of Sandra. But more than that, I can sue Benita. If I'm having to pay Sandra a greater fee than I had agreed to pay Benita, I can get the excess money from Benita. So not only does she not have any rights to sue me, alternatively, I have rights to sue her for the excess money that I'm having to pay Sandra. Think about it. Okay? That's a condition. Condition is fundamental. It goes to the root. The other type of term, which is not a condition, is a warranty. And a warranty doesn't go to the root. It is superficial. It lies on top of the contract. It's not a major element of the contract. We have the case Bettini and Guy. Guy, spelt differently, is a man's name in the UK. Betty is a woman's name in the UK. But Bettini, you probably remember Bettini easier if you think back to the 1974 World Cup in football. Because the man who played at the front for Italy was a man called Bettini. Oh, you remember? Yeah? So Bettini and Guy was about, well, I'll just vary the facts a little bit. It was about an opera singer who was engaged to perform at 4 concerts and attend a rehearsal period for a week before the first concert was due to begin. And the opera singer gave notice before the rehearsal period and said, "I'm not going to be able to make it for Monday, Tuesday, nor Wednesday, but I should be there on Thursday. I should be okay to attend on Thursday and Friday, and I'll even work over the weekend to help the orchestra to rehearse, and then we can be ready to start the first concert on the Monday evening." And the promoter, having taken this notification from Christina that she's going to miss the first 3 days of rehearsals, the promoter goes back to his favorite one, Sandra, and says, "Sandra, can you take over and do these 4 concerts for me?" And she agrees. And on the Thursday, Christina turns up and says, "I'm here to help you rehearse." And I say, "You've breached the contract. I've treated it as discharged. I've engaged the services of an alternative singer, so I'm very sorry, but you'll have to go." And she sues me. She's breached a condition. She's breached a warranty. She's not breached a condition. A warranty is not a major part. A condition is a major part of the contract. What she has breached is a subsidiary element of the contract. And I cannot treat the contract as ended. The only thing I could do is that I could sue her for any excess money I have to pay to Sandra to help me to rehearse the orchestra on those 3 days. But the contract is not discharged. The only right I have as an injured party is to sue Christina for the surplus money I have to pay Sandra. But I didn't. What I did was I treated the whole contract as discharged, and it means that Christina can sue me for breach of contract. There's a big difference between breaching a condition and breaching a warranty. Innominate, the French, what's the French word for name? Do you know? Are you fluent in French as well as 15 other languages? The French word for name is nom. And an innominate term means it's a term with no name. We don't know. We don't know whether this term with no name is a condition or a warranty. And we won't know until it's actually broken. And then we can determine how important it was, how fundamental to the contract this term is. So only when it's broken can you make the decision of the importance of the term. And there's a case which is mentioned there at the bottom of page 27, Universal Furniture Products and Maple Flock Company. What's a flock? I've already mentioned it this morning. What's a flock? A flock is the collective group noun for a lot of sheep. That's what a flock is. But that's not in this context. Flock has two meanings. So flock is sheep. We've already mentioned sheep this morning. We had sheep yesterday. Where did we have sheep yesterday? Sheep on the ship. Well, not on the ship. Sheep in the sea. Yeah. Well, they were originally and then they weren't. So flock in this context is different. Flock is the padding in the back of chairs or on the seats of chairs. The stuff which makes the padding is flock, and it's material which is cut up into tiny pieces. So it's not solid in any way, and that's what this maple flock is. It's material which is cut up for the purposes of putting into the backs and the seats of chairs. What's maple? Do you know what maple is? It's a tree, yes, and the maple leaf is the symbol on the Canadian flag. So when you're walking up here in the morning, you look up and you see the American flag flying outside, but you'll also see a Canadian flag flying outside with the maple leaf shown on it. So just a little silly things like that to help you remember. Oh, every time you walk up school as Yale, you're going to say flock, maple flock, Universal Furniture Products, innominate terms. And it will help you. Possibly. So Maple Flock Company was a case about the delivery of 100 tons of flock. And it was to be delivered in 20 installments. So here I am, I'm the flock company, I'm supplying this flock. And the first 15 installments that I supplied were fine. They were accepted by the Universal Furniture Products Company. They used them in their production. They were happy with everything. And then for whatever reason, the 16th was defective. It was a bad delivery. It was bad quality. It wasn't suitable. And so legal action starts. And the buyer says, contract discharged. I'm not buying any. Don't send any more. If that's what you're going to send me, I don't want to deal with you. And the flock delivery people said, no, this is not a breach of condition. This is a breach of warranty. If it had been the first installment, which was wrong, then that would have been a breach of condition. That's an indication of the quality of the material I intend to deliver, and if it's not acceptable, then that's a breach of condition. If it had been the second one, and not the first, that had been wrong, that might be treated by the court as a breach of condition, because 50% of my deliveries are not up to standard. But we're beginning to get into a query situation here. What about if it had been the third one which was wrong? The first two were okay, the third one was poor quality. Well, I'm beginning to move into the area of warranty rather than condition. The fourth, the fifth, the eighth. If that one had been wrong, the first 7, the first 35 tons were acceptable, and I made a mistake with the eighth one. And the court would probably say, well, the likelihood of another wrong delivery is not big. It's, all right, I accept I made a mistake with the eighth one. But I will correct it, I will replace it, and then number 9, 10, 11, and so on will be fine. So it depends on the likelihood of further breach. It depends at what stage during the contract the breach takes place. Is it an early one, in which case it's probably breach of condition. If it's a later one, or even 8, 7, 6, 5, 4... And as you move closer to the front of the contract, the more likely it is to be a breach of condition. The further away from the start of the contract, it's more likely to be a breach of warranty. And that's why it's called an innominate term. We don't know, until it's broken, whether it's an important break or a less important break. In this one, it was not an important break. The 16th delivery was defective. And the court said, no, replace the 16th and then carry on with 17, 18, 19 and 20. I'm still on terms. I've turned the page. I'm on page 28. Remember, I just read a question out to you. Identify when contractual terms may be express and may be implied. So that's where we're looking, page 28. Express terms are those terms within a contract which are specifically discussed between the two contracting parties. We've specifically discussed them, we've talked about them, we've agreed upon them, and those are therefore express terms. They don't have to be written, because remember, a contract may be a contract, an oral contract. It doesn't have to be reduced into writing. But we did talk about them, and we did agree upon them. An implied term is not previously discussed. It is implied into the contract. Now, they may be judicially implied or they may be statutorily implied, but they're terms which we have not anticipated, they're terms which we haven't discussed, they're terms which we have not agreed upon. Judicially implied terms, I've given you 3 circumstances where the court, judicially implied means the court will imply a term into a contract. Sometimes statute itself will imply a term into a contract. So we have judicially and statutorily implied. And judicially implied, as I say, I've given you 3 situations. Business efficacy. Efficacy means we need to imply this term in order to make it a realistic commercial agreement. If we don't imply the term, it makes a nonsense of the agreement. I've given you 2 examples. I'll only talk about one of them, again, because we need to move on. The Moorcock. If there's a case involving a ship, it's often known by the ship's name. If there's a case which involves a ship, we'll often refer to that case by the name of the ship. And in this case, we have a case called a ship called the Moorcock. And the Moorcock is chartered to deliver a cargo. You've no need to write this down. Pig iron. It's delivering a cargo of pig iron. I think pig iron is raw iron which has not been processed. I don't know, but that's what the cargo is. It's a cargo of pig iron, which is very heavy because iron is a very heavy metal. And it's to be delivered to a pier sticking out into the River Thames. So there's our pier, and there's the River Thames. And this boat, this barge, is chartered to come up the river and to pull alongside the wharf where it can then be unloaded. The owner of the wharf and the barge owner knew that just off this wharf there is a sandbank. And if you don't time your approach correctly, you'll run onto the sandbank. The tide will be too low, it won't be high enough, and you'll land on the sandbank. So the timing is quite critical. And the barge owner was asked to come along and deliver the pig iron to the wharf. Wharf owner knows the sandbank, the barge owner knows the sandbank, but what neither of them knew was that underneath the sand there was a sharp rock. So along comes this barge, heavily laden with pig iron. It mistimes the tide, and it lands on this sandbank. And as the tide goes out, the ship settles down, and the sharp rock goes through the bottom of the ship. We're claiming on insurance. Whose insurance? Should it be the pier owner, his insurance company that pays, or should it be the barge owner's insurance that should pay? Well, there's nothing in the contract about if the barge lands on a sandbank with a sharp rock underneath it and the sharp rock goes through the bottom of the ship, then it will be the responsibility of the barge owner. There was nothing in the contract about whose liability, whose responsibility it is. So it needs to go to court, and we'll let the judges decide who's responsible for the damage caused to this barge. And the court eventually comes up with the statement, well, you tell me, what would you come up with, Eddie? Is it the pier owner or is it the barge owner whose insurance should have to pay? The barge owner. Leanna? The contract only existed on the understanding that the pier owner says to the barge owner, deliver these tons of pig iron to my wharf, implied, and it is safe to do so. So the warranty is being given by the pier owner to say, yes, you can do it. Even if you land on the sandbank, everything is okay because it's sand, and you can wait for the tide to go out and then wait for it to come back in again and float your ship off. So it has to be implied that the pier owner was saying to the barge owner, it is safe to do so. So it was the pier owner's responsibility, and it was the pier owner's insurers that had to pay. That's the Moorcock. You can look up Express newspapers for yourselves. So Moorcock is an example of judicially implied in order to give the contract business efficacy. But the courts will also imply, the judges will also imply, where there is trade custom. If it is generally accepted within the business that this should apply, then the court will imply that this is applicable to our contract. The case Houghton and Warren. Houghton and Warren. Warren is a name for an Englishman, so this is in your list of forenames. This is about a tenant farmer. And the tenant farmer was given notice in April that he had to leave the farm in September. The owner of the land said, I don't want you farming my land anymore. You'll need to leave in September. But of course, the farmer needed to work the land between April and September. He had to look after it, he had to cut it, he had to grow the hay, he had to look after the land in this period. And he did a lot of work involved. But he was not able to get the benefit of that work because September was before he was going to harvest or before he was able to sell the crops that he was growing. So when he left in September, there was a lot of work that he had put onto the land, the benefit of which he was not going to receive. And there was nothing in the contract about him being able to claim for all this work the benefit of which he has not received. So he sued the landowner, because the landowner was refusing to pay him anything. He sued the landowner, and the courts established that it is trade custom, that if a farmer works the land and doesn't get benefit because he is required to leave, he should be able to claim a reasonable amount in respect of the work that he has done. That's trade custom. And the third example I've given you for judicially implied is where there is a course or a history of trade between the two. A course of trade or a history of trade between the two. And I've given you the case Hyllus and Arcos. What was the name of Noah's boat? Noah, from the Bible, the big flood, and what was that? 2 of every animal put on, and then they sail off. And what was the name of his boat, Jana? The Ark. It was called the Ark. So I think this one is probably in your ship list. It's a bit of a stretch of imagination, but the Ark should be in your ship list. Hyllus and Arcos was about the supply for 1930 and 1931, 2 years' supply of the product, or of the goods, Russian redwood. Timber. Timber is dead trees, cut down trees which are then chopped up, and that's an interesting thing about English, isn't it? Isn't this strange? What a strange language. When you fell a tree, when you knock a tree down and then subdivide it into little bits that you can feed into the fire, we would say you chop it down and then you chop it up. Which is most strange, isn't it? You chop it down and chop it up into little pieces. So there we are. The Hyllus and Arcos, the supply 1930-1931 Russian redwood. The redwood was delivered throughout 1930. And then at the start of 1931, the buyer said, I don't want any more. And you can't sue me because it says within the clause, within the contract, it says that the quality will be as normal. But it didn't actually specify the quality, it just said the quality will be as usual. And they said, we're claiming that the quality you're delivering is not up to standard. And because of the vagueness of the term, another word for vague, what's another word for vague in the context of contracts? Another word for vague. Tell me again? Uncertain, yeah, but particularly with reference to contract, there's a strange word. What in British measurement, English measurement, roughly, what's the length of the distance between that knuckle and the end of my thumb? The length is 1 inch, yeah. And there are 12 of those in a foot, all right? And there are 3 feet in a yard. And then we get into excitement. You get 22 yards in a chain, and 10 chains in a furlong, and 8 furlongs in a mile. It's all very easy. So this particular, it's a strange word, vagueness or incomplete, and the word is inchoate. Inchoate. An inchoate term is an incomplete or vague term. It's incomplete because it's not totally certain. And we have here in this case Hyllus and Arcos. we have an inchoate term with reference to the quality of the wood to be delivered. And of course the supplier says, listen, we're in contract here for 2 years. You've only had 1 year's delivery. I have a contract with you to deliver another year's worth of Russian redwood. And the buyer says, no, I don't want it because the quality term is inchoate. Because it's vague, it will not be enforceable by the courts. And the court looked and said, well, actually there's a history of trade between the two of you. There is a history of trade. Throughout 1930, wood has been delivered and accepted by you. You've accepted that the quality of the wood delivered for the first year was okay, and therefore so long as the supplier continues to supply wood of that quality, then you have to accept it. So the court will look and say, judicially implied, there is a course of trade. The implication is that once you have started accepting goods of a certain quality, then you should continue to accept goods of that quality. Those are 3 situations where the courts may be asked to determine whether they will imply a term into a contract. This is stuff which is not expressly, clearly agreed. That will be an express term. So the courts will read in to a contract to give it business efficacy, in accordance with the fact that it's trade custom, or because there is a history of trade between the two people.